Rolling. This is the FedSoc Films podcast,
where we continue the conversation
sparked on film.
Quiet on set.
You want to know what freedom tastes like? It tastes like this beer.
Take one.
This is, in fact, the classic solution in search of a problem.
Action.
That cannot help but be controversial.
Cut.
With expert discussion and analysis.
With the greatest legal minds on the topic today, the FedSoc Films podcast. It's a wrap.
Welcome to the FedSoc Films podcast. I'm Matt Wood, director of FedSoc Films. In the film Taking Poletown, we explored the battle between homeowners in the suburb of Detroit called Hamtramck, but known as Poletown, and the city of Detroit and General Motors over the use of eminent domain to take and transfer property from those homeowners so that General Motors could build a new car plant. This took place in the 80s, and Detroit was in rough economic shape at the time, and the plant promised much-needed jobs and economic development. After a legal battle, the Michigan Supreme Court finally decided in the case called Poletown that they upheld the transfer of this property, and over 20 years later, that remained the law of the land. But in 2004, a new case was decided before new justices of the Michigan Supreme Court, and that case would overturn Poletown. This was the case called Wayne County v. Hathcock. We have a special guest today to continue our conversation about Poletown and eminent domain, and that's none other than Justice Robert P. Young, Jr. Justice Young was first appointed to the Michigan Supreme Court in 1999 and became Chief Justice of the Michigan Supreme Court in 2011. Notably, Justice Young authored the decision that overturned Poletown. He was also featured in her film Taking Poletown. Justice Young, welcome to the FedSoc Films podcast. Thank you for being here with us today.
Thank you for asking.
Well, Justice Young, I'd like to kick things off. I'd love to hear your story. What was the journey that led you to become a Supreme Court justice in Michigan? And was that always a goal of yours when you were young?
No, my career, I like to say, is a series of fortuities. I had in college intended to become a professor of political science and was going to take a joint program between the Graduate School of Government and the law school. And I was admitted to both, but the dean of the Graduate School of Government called me and said, "We don't really care for you doing a joint program." And I said, "Well, goodness, everybody's doing joint programs." And he said, "Well, we don't like it." I said, "Why don't you think about it and call me back?" He called me back and said, "No, we still don't like it." So in a fit of adolescent hubris, I told him to pound sand in slightly stronger language and found myself in law school. It was the worst 3 years of my life, and I eventually ended up back in my hometown of Detroit with one of the oldest and largest firms in Michigan, and found out, to my surprise, I loved the law. And I spent roughly 15 years as a partner there, and then I was asked by one of my clients, AAA of Michigan, to become its general counsel. I was there for 3 years, and the governor called and asked me if I'd like to join the Court of Appeals. And I had been particularly upset by that court and agreed to join the Michigan Court of Appeals. And 3 years later, he called and asked me to join the Supreme Court. So none of it was planned. It just sort of happened.
Well, very good. I guess sometimes the best things in life happen that way. So how did you experience the fight over Poletown? Did you live in the area at that time? And what did you think about what had happened, including the court case of Poletown?
Well, yeah, my wife and I returned to Michigan in 1978. I was in my firm, Dickinson Wright, and we're all quite aware of the conditions of Detroit. Detroit was very much in economic distress. It was hemorrhaging jobs in the early 80s. The auto industry was particularly under siege by foreign imports, particularly the Japanese imports. Joblessness in 1980 was running 18% in the city. And Detroit Mayor Coleman Young persuaded GM to build a new modern plant on the site of the then defunct Chrysler Dodge main plant, a plant that I had actually worked in the summer before I went to college.
Really?
Yeah, and that the footprint of Dodge, Maine, was then to be supplemented by additional surrounding property in a community known as Poletown that had been the center of the Detroit's Polish community for more than a century. The additional Poletown properties that had to be assembled for the whole plant were to be acquired by condemnation, by takings. So that's kind of the background. Detroit, in effect, had a gun to its head in an economic sense, and GM, the plan to build a new modern plant in the city, obviously was a boon to the city, a great economic benefit to the city, as described by Professor Moak in your FedSoc video, Taking Poletown. He contended that the condemnation of these Poletown properties was justified as, quote, a public necessity to, quote, alleviate unemployment and cause a benefit to the public, which was primary, and the benefit to GM incidental. That is the view that a majority of the Poletown Supreme Court decision also held. As I said, unquestionably, the creation of new jobs was a major economic benefit to Detroit, but I do question whether it could be accurately characterized that the benefit to GM was incidental. GM paid $18 million to Detroit for the new plant project. The development cost borne by Detroit was a fifth of $1 billion, and GM was granted 12 years of tax abatement. To Professor Moak, that apparently was just walking around money. When it was announced, this project was announced, and the condemnation of Poletown became apparent, the residents of the community objected and eventually sued to prevent the taking of their homes and businesses. And that case eventually found its way to the Supreme Court in 1981. And the court decided that case in just 10 days. That is an extraordinarily short period of time. Most Supreme Courts can't even make a motion to adjourn in 10 days.
So one thing I'd like to ask about is you mentioned something similar in the film, but we didn't get to really expand upon that. Why do you think the court made a decision in that time frame?
I believe that the court was feeling enormous pressure to get a decision out, so that this whole project didn't collapse. If the court had held in 1981 that the taking of the landowners in Poletown's property and giving it to GM, another private citizen, was unconstitutional, the economic repercussions would have been quite dire. And the speed, all I can say is the extraordinary speed of this decision is suggestive of the feeling that the court felt pressure. I don't know of any extrinsic timeline that was pressing at that point. I don't know that GM said, if I don't get an answer by X, we're going to Ohio. I know of no, as I said, external reason that would explain that kind of precipitous decision making. But it in my view, it was an extraordinarily short period.
So when this was going on, and the Michigan Supreme Court at the time ruled that GM could have the land to expand their plant, What was the feeling like in around Detroit? Was this something that most of the public and the citizens were aware of and paying attention to? Was this
Oh yeah, it was in the news um, regularly because the citizens were lashing themselves to prop their own property. There's this is a Catholic community. The church, whose name I forget, Catholic Church, was the center of that community. And when it came time to demolish the church, the father of that presided there led the public opposition to this GM condemnation. And I mean, you just have scene after scene on the evening news and in the local papers of the agonies of Poletown residents and businesses who are facing the prospect of losing their property. This, as I said, this had been a Polish identified community for more than a century. It was a very close knit community just on the perimeter of Dodge, Maine.
So the Michigan Supreme Court allows for the taking to take place, and then the plant gets built. And for a little over 20 years, that was the law of the land until Wayne County v. Hathcock comes around, and you were actually on the Michigan on the court at that time. And you authored that decision. So I'd love to hear that story from your perspective. But first, I'd like to play a short clip from our film, Taking Poletown, where you discuss Hathcock, and then we'll come back and talk about it. So very good. So go ahead and play the clip.
Because I was the author of the Hathcock decision that overruled the Poletown decision.
The court, until Gregory, the plurality of Gregory, had always sort of respected that there is a much narrower zone of acceptable public uses. Well, and Poletown represents a quantum leap, a divorcing of that notion of use entirely.
So, Justice Young, first, tell us the story of the case of Wayne County v. Hathcock. But I'd love to hear by what you meant in that clip. And part of that clip, I believe, is when you are announcing the decision in the actual Hathcock case.
No, that was the oral argument.
Oral argument, okay. And you say that it was a quantum leap in the understanding of public use. So I'd love to hear a little quick backstory of Wayne County v. Hathcock for our audience. But what did you mean by this was that Poletown represented a quantum leap in the understanding of public use?
Right. Well, let me first let the audience know what our Constitution provides. Private property shall not be taken for public use without just compensation. So that's what Poletown purported to be interpreting, and what Hathcock purported to be interpreting.
And that's the Michigan state constitution.
That's correct. That's our 1963 state constitution. The background of Hathcock was that the Detroit Metropolitan Airport, which is roughly 15 to 20 miles outside the city of Detroit in Wayne County, had begun expanding the airport. And as a result of that, the FAA gave it some funds to create a buffer zone, because with expansion came additional airport noise. And so they began to develop a plan for this additional property, which became known as the Pinnacle Project. And the idea was that they were going to create an economic development zone, an enterprise zone of new businesses. And they acquired a number of the surrounding properties relatively in the normal process. They offered and people sold. But there were a number of businesses that I think they got 1,000 acres, and they needed 1,300, I think they believed, and they were shy 300 of those. And so they decided to use condemnation, a taking, to acquire those additional properties. Obviously, the property owners who held out against normal negotiations objected. Litigation ensued, and the case again wound its way up to the Michigan Supreme Court. And let me just back up a little bit because the framing of this issue is important. As framed by the Poletown majority of the Supreme Court, the taking issue before it was, quote, can a municipality use the power of eminent domain granted to it by the Economic Development Corporations Act to condemn property to transfer to a private corporation to build a plant to promote industry and commerce, thereby adding jobs and taxes to the economic base of the municipality at stake? The Poletown majority answered yes, but a unanimous Hathcock answered the same question no and overruled Poletown. So the issue here is what is public use? And I think people can understand when a government takes property to build a railroad, build a highway or a school or some other a government edifice. I think most of us would be balk at the notion that a public use is when the government takes the property and gives it to another, for one private individual, and gives it to another. There's nothing public about that use. So the question in Hathcock was whether the taking in around the airport was consonant with our Constitution. Wayne County argued in Hathcock that its challenged takings advanced development of the surrounding metro airport by promoting the growth in industry and commerce, a term that the Supreme Court in Poletown had used, and that it was supported by Poletown. The property owners obviously argued that the taking of their property was not for a public use, and that that was the only kind of taking that was permitted. So the primary issue in Hathcock was whether Poletown was properly decided. And we held that a person's property cannot be taken by the government and given to another private person, no matter how much industry and commerce might be advanced by the taking. And we overruled Poletown, unanimously so. And we recognize that we have more than 100 years of history in our case law interpreting prior constitutional takings clauses that were similar but not always exactly the same. And we found that there were really three categories where a taking could be justified where the property ended up in the hands of another private entity. And the first was where public necessity was of an extreme sort that requires collective action, like building a highway or railroads. The second is where the property remains subject to public oversight after transfer to a private entity, like regulated pipelines. And the third was where property was selected because of what the cases had described as facts of independent public significance. That's just a fancy way of saying that the reason for taking had nothing to do with the interests of the private entity to which the property was eventually transferred, and that third category was based on the slum clearance cases, where the city of Detroit, in that particular case, had decided that the area was a public hazard and it needed to be addressed by removing, dilapidated housing, etc. The Pinnacle Project wasn't an enterprise whose very existence depended on the use of land that could only be assembled by the government. We have plenty of business enterprise zones that are done in private sector without intervention of government. Second, it wasn't subject. The project was not subject to public oversight. That the property continued to be used for the benefit of the public after sold to the private entities. In fact, the opposite was true. The developers they got the property were to pursue narrowly their pecuniary interest. And finally, there was nothing about the act of condemning the defendant's properties that served the public good in this case. And the only public benefits cited by the Wayne County arise after the lands were acquired by the government and put to private use. So unlike the slum clearance case, there was no independent public significance in the need to take the land in the first place for public health or safety. So none of the three broad categories of takings where the end user was not the government itself had been approved were applicable in this case.
And then what was the final decision in Hathcock? What did Hathcock state?
Hathcock stated that the government cannot take private property from one individual and give it to another to enhance economic welfare, for higher taxes, for all those things that Poletown had encouraged. What Poletown was nearly the first state court decision that recognized government takings to promote economic development. And it created a boomlet of takings of that character across the country.
And so if you were to examine Poletown under this three-pronged test, is that why you said that Poletown represented a quantum leap in this understanding of public use? Do you think that if you were looking at Poletown, that it did not meet that three-pronged test either, like Hathcock?
Clearly not. That's why we overruled it.
And so after that, what then happens? There's this decision that you authored, and then after that, there's a constitutional amendment to Michigan's constitution. How did that come to be, and what was the result of that?
Well, I believe that Hathcock, in ways that most of our decisions do not, really resonated with the citizens of Michigan, who take a lot, like everywhere, every homeowner or property owner takes a great deal of interest in their own property. And I think being fearful that another Poletown court could be come into existence, they decided to make that impossible. And so 2 years after Hathcock, the takings clause was amended to provide public use does not include the taking of private property for transfer to a private entity for the purpose of economic development or the enhancement of tax revenues. Private property otherwise may be taken for the reasons of public use, as that term was understood and effective as of the date of the amendment to this Constitution that added this paragraph. So that anchors this constitutional amendment in Hathcock's construction of the takings clause.
And what is it like to issue such an influential decision like Hathcock with the Supreme Court, with a case like that, with an amendment that follows. Most of our viewers will never have served on a Supreme Court or have that experience. What is that like to be someone who is in those robes, issuing decisions like that, making those cases? How does that weigh on you?
Well, I have a personal anecdote. The decision came out at the end of our term, and our family periodically has family reunions, and it selects a place, and we go to a hotel. And the morning the decision was published, I came down, and my family erupted in applause. That was kind of
Wow.
It was a moving moment for me. So, but they were property owners, so I suppose it meant something to them.
Do you stay in close contact with the community there? Is there much that you're doing now where this case relates to work you're currently doing or people that you're working with?
No, I actually had, other than working as a high school graduate at Dodge, Maine, I really had no direct contact with Poletown. I read and saw the news reports while the project was being announced and implemented. But no, that Poletown is destroyed, as illustrated in your video taking Poletown. It's entirely destroyed, and that's really something that is. It's not a legal issue, but it's a background issue. I want to note that a few months later, in Kelo versus New London, the United States Supreme Court had a very similar case that involved a development project for Pfizer in New London, which required the condemnation of another one of these old neighborhoods. In Kelo, the U.S. Supreme Court closely divided, but permitted the takings to accomplish economic development of the United States Constitution. Doesn't affect our state constitution. Ours can be narrower than the grant of authority of takings under the U.S. Constitution. And here's the thing. The New London development, after all those properties were condemned, failed. And that's been characteristic of a lot of these economic development takings. There's a lot of promises on the front end and not so much delivery on the back end.
So how should the government balance these interests of economic development and private property? What are the safeguards for eminent domain? Or what should they be?
Well, you should follow the Constitution. I mean, the Constitution says the government can't take your property to give it to somebody else. They have to take it for a public use.
In Poletown, it was a unanimous decision, and that's 7 justices decided one way. Then, a little over 20 years later, in Hathcock, it was unanimous the other direction. So 2 questions.
Say that again?
So in Poletown...
Poletown was a divided decision.
It was divided, Divided. So then we get to...
It was a majority.
A majority.
A bare majority.
And then we get to Hathcock, and it was unanimous. Were there justices that were in the Hathcock court that decided in favor of overturning Poletown, who were also on the court during Poletown that either voted in favor of upholding that or in dissent? No, it was a totally new court?
Yeah.
Do you think it was just that there were new people on the court, or was there a different way of assessing these legal issues that had come up 20-something years later?
Well, I think one of the um, differences in the two courts was that the Hathcock court had a majority of justices who believed in originalism, that a judge is constrained to ascertain the meaning of the words in the Constitution as the ratifiers would have understood it, not to project onto the Constitution as though it were a Rorschach inkblot some notion of the common good. And that was a really important philosophical difference, I think, between the two courts. The idea that judges should do good versus the idea that judges should not do good, but justice under law. Those are two very different things. You and I may have very different ideas about what is good, but there's probably more possibility of agreement about what words actually mean. Not that it's math, but when you're looking at the words and trying to understand what they mean and in the context of the ratification of them, that's a much narrower focus. And I think that's a critical difference between the prevailing philosophy of the earlier Poletown court and the later judicial philosophy of the Hathcock court.
So besides from the statutory words that you can look at when you were helping make this decision, what else were you looking at? What case law? I know the late Justice Cooley was important in understanding the case law in Michigan around eminent domain. Is that correct?
Right. Well, we looked at the entirety of our jurisprudence on takings. As I said, we had several prior constitutions. Not all of them contained exactly the same language. A prior constitution had use and benefit, public benefit. That's different from use. That's more public benefit is more like what Poletown was focusing on, not public use. And so some of the cases in the earlier era may have relied on a broader constitutional authorization. But once in 1963, the Constitution deleted public benefit and retained only authorization for takings for public use, that is a constitutionally significant change that we were obligated to give deference to.
Certainly. So after Hathcock, you mentioned there was Kelo, which is a fairly famous case. And
infamous, some would say.
Some certainly would say. So, and that was, I believe, 2005. So over 15 years ago. What is the legal landscape of eminent domain? And I suppose, especially when we're talking about transferring from private party to private party, currently, has there been much development in Michigan since Hathcock and the constitutional amendment that followed, or has much changed?
Well, yeah, everything changed because now the government can't come and say we've got a big box store that's going to add tax revenue. Thank you very much. Give me your property. That's gone. I mean, those public urban planners hate Hathcock because, as Professor Moak stated, it's taken an entire category of beneficiaries out of the equation. No longer can you take property to maximize profits for a private company or alleviating unemployment in the community because unemployment isn't a public use.
Have there been challenges to the new amendment? Are there any cases or any attempts to push back in the other direction since then?
Not as far as I'm aware. I mean, if Hathcock hadn't put a pin in this practice of taking private property and giving it to rich corporations, the amendment surely does. I read it to you, and it makes it very clear that that whole enterprise of corporate entities getting the benefit of takings is dead. And that, I mean, I know after Kelo, there was a boomlet of state legislators that started contemplating whether their own statutory regime or constitutional regime was sufficiently tight to avoid the Kelo type outcome. I didn't follow closely after a certain while to see how many actually, like Michigan, prevented that practice, but Kelo did have that response.
But in Michigan, it seems that there is certainly has been a lasting effect from the case that you authored. So I'd like to ask about the film taking Poletown and see, is there anything that, looking back, that you think we could have explained better, or something that we may have just missed or left out for time, or anything you think it would be good for our audience to know that we didn't get to in that film?
No, I thought it actually did a wonderful job of telling the very emotional story about this community that was destroyed by these takings. And I thought that there was enough legal architecture in the video, the byplay between Professor Moak and me in our various segments, to give people enough understanding of what was at stake. Again, the core issue is, what is public use? Not benefit, what is public use? And at least in Michigan, we have now constrained government from taking the property unless it's literally for some governmental enterprise like a school or a library or government building, unless it fits one of those three areas that I described earlier.
Well, very good. We certainly try to do a good balance of telling an interesting story, but providing our audience with context from varying sides and perspectives of these important issues. And we certainly appreciated having your insight and unique viewpoint included in there. Just a couple final questions. One is similar to the last one, but a little more broad. Is there just anything else that you would like to talk about on these issues that we haven't discussed so far?
Well, I think we touched on it a little elliptically in talking about the judicial philosophy of the two courts, Poletown versus Hathcock. I think people need to understand that judicial philosophy is a very significant issue. And the question that they must keep in mind, depending on no matter whatever selection process they have for judges, they need to ask themselves whether they think judges are or should act like philosopher kings, or have a much more constrained and, in my view, constitutional role of trying to interpret words. There's a whole judicial school of philosophy that I call Rorschachian. That's the psychological test where a person is exposed to ink blots. They're just ink blots, but they're asked to interpret what those blots are. They obviously are projecting onto those blots their feelings, because the blots have no particular meaning. And a lot of judges are Rorschachian in that sense. They think they are entitled, by virtue of wearing a robe, to project onto the Constitution, onto statutes, onto people's private contracts, their view of what's best. I just don't think judges are smart enough to be able to do that. And it's not consonant with the obligations attendant to a constitutional republic to anoint judges to be our philosopher kings. We got rid of royalty, and we are self-governing. And to be self-governing means that when we enact our constitutions, when we enact our statutes, the lawgiver is the people in the case of the Constitution, and the legislature in the case of statutes. And in the case of private contracts, the contracting parties. So judges shouldn't be rejiggering any of those to suit his or her personal, moral, social, or political philosophy. They should be trying to figure out what those words actually mean and then doing that. And
Well,
that's an important question for our society today.
It certainly is an important question, one that we explore here on a regular basis. I suppose it becomes more difficult when laws may be vague or it's been a long time and words have changed meaning since then.
Well, that's a good point. Again, the question isn't whether words change meaning over time. The question is, what was the meaning when they were put in the Constitution? That's the difference between a person who believes in originalism and original intent, and a person who believes they can apply modern ideas to a document. In the case of our United States Constitution, is a couple centuries old.
I think this is a great place to segue to my final question, which I think is somewhat similar, which is the idea that a lot of what we do at FedSoc Films is with the idea that the law matters, and we want our audience to better understand these issues and why they matter. So I think with this in mind, that justices and judges are going to be interpreting laws, why should people care about these laws like that we're talking about here, eminent domain? Why is this important to people? Why should people care about these issues that we're discussing and that people like yourself often make rulings on?
Well, all you have to do is look to the citizens of Poletown who lost their homes, their livelihoods, and their community because of how expansively a Supreme Court chose to interpret what public use meant. It matters every day, whether it's your property, whether it's your contract, whether it's your rights under a statute. When judges fail to apply the words before them, they're actually acting as a rogue. They're not acting in accordance with the law, they're acting against the law. And judges aren't constitutionally authorized to do that. And so that's why the citizens of the United States ought to pay very close attention, whether the judges are elected as they are in Michigan or appointed by the president with the advice and consent of the Senate in the United States. It really matters whether those people who are up for judicial selection believe that they are tethered to the text or whether they get to exercise whatever their gut tells them.
Some very good food for thought. I think we're going to leave it there. I think we took a lot of your time, and I certainly appreciate it. The last thing I would ask is if you would tell our audience where they can find out either more about you, your work, or just places you think are good resources for the topics we've discussed.
Well, obviously, I'm retired now, so I'm a private citizen, and I don't think anybody is concerned to what Bob is doing these days. But certainly, you can read the opinions themselves. They're a little hard going. You have to be particularly masochistic if you're not an insomniac to read them, but they are there, and there's a whole body of literature, legal and public policy, that talks about takings. I mean, people like Professor Moak were wroth about this loss of what they thought was an essential public policy tool to manufacture a better society. And he's right. Hathcock and the subsequent constitutional amendment do eliminate from the city's purview the right to take your property and give it to somebody else who use it presumably for more profitable enterprise. But there's a whole literature out there about this very issue that people can access just by going on Google and typing in takings or public use, things like that.
Well, very good. Google often is a good place to start looking for information. Well, Justice Young, I appreciate your time. I really do appreciate you spending time with us and chatting more about these issues, and I'm sure our audience will as well.
Thank you very much for asking.
Well, very good. Well, our guest today was Justice Robert P. Young, Jr. He served on the Michigan Supreme Court from 1999 to 2017 and was the Chief Justice starting in 2011. Of course, he authored the opinion of Wayne County v. Hathcock, which overturned the decision of Poletown, and he was also featured in our film Taking Poletown. This episode on eminent domain, Hathcock and Poletown, was in connection to our film Taking Poletown. You can check out the film on YouTube, Facebook, or fedsoc.org. That's FEDSOC.org. Thanks for listening, and don't forget to subscribe for more episodes of the FedSoc Films podcast. As always, the Federal Society doesn't take any positions on the issues discussed. That's a wrap.
This has been a FedSoc audio production.